I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. And we're in the same courtroom, same courthouse where Derek Chauvin was convicted of murdering George Floyd. But the trial we are watching is so much different. So much different on so many different levels. But I want to focus here on the use of force. The use of force by Kim Potter. We know she yelled taser, 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 attempted to use her taser, thought she was going to use her taser, but used her gun. And we have had witnesses called by the prosecution, police officers who have come in there and said, it was reasonable. I would have done it. It was justified. The use of the attempted use of a taser in that situation, or the use of deadly force. And this is the prosecution case. Remember what happened in the trial of Derek Chauvin. There were no police officers coming into that courtroom and saying what Derek Chauvin did was right, what Derek Chauvin did was justified, was part of his training. No officers were saying that. But in this case, it's different. Police officers testifying for the prosecution, called by the prosecutor, witnesses, supervisors, training officers, all saying that, yeah, the use of a taser would be justified under those circumstances. And you had the supervising officer, Officer Johnson, say, yeah, deadly force justified under the circumstances. It wasn't until today that finally prosecutors put a witness on the stand who testified that the use of force was not reasonable under the circumstances. It wasn't an officer, it was a paid expert. Happens at every trial, both sides hire experts. But you remember, in the case against Derek Chauvin, there was one expert who justified what Derek Chauvin did. It was a paid expert for the defense. In this case, this trial, everything is flipped over because the only person saying that it was not reasonable is a paid expert, but for the prosecution. By the way, same expert used by the prosecution in Derek Chauvin's case. Take a listen.
Do you have an opinion to a reasonable degree of professional certainty about the decision to attempt to use a taser at that point in time?
Yes, I do.
And what is that opinion?
Taser use is inappropriate under those circumstances for very similar reasons as why using deadly force against the operator of a motor vehicle is inappropriate. It's really dangerous to incapacitate the way that a taser can incapacitate someone who is in a position to get a vehicle moving. You can create an unguided hazard. If the taser was effective in achieving what the manufacturer refers to as neuromuscular incapacitation, and if the taser was ineffective, if it did not achieve neuromuscular incapacitation, if it just caused pain, what we call pain compliance, then you're providing an incentive for someone to flee in that circumstance. So you're likely to actually incentivize someone to effect their flight.
Do you have an opinion to a reasonable degree of professional certainty as to whether Officer Potter's use of deadly force in shooting Mr. Wright with your gun was justified?
I do, yes.
And what is that opinion?
That the available evidence leads me to conclude that a reasonable officer in Officer Potter's position would not have concluded that there was an imminent threat of death or great bodily harm, and thus that the use of deadly force was excessive, that is, disproportionate to the threat presented. And regardless of whether the reasonable officer would have perceived an imminent threat of death or great bodily harm, the use of deadly force under the circumstances was inappropriate because of the danger that it created to the other two officers and the passenger in Mr. Wright's vehicle.
That's his testimony. Let's bring in Court TV legal correspondent Chanley Painter, who's joining us live from Minneapolis, Minnesota tonight. Chanley, great to see you. I have a couple questions here right off the top. So we heard what they should not have done. Did this expert tell the jury what they should have done when they got to the point where Daunte Wright had gotten out of custody and was in the car, and Officer Johnson's leaning in on the other side, trying to prevent him from driving away?
Well, it wasn't very clear, but it seemed, based on his opinions, that the use of force of a taser would not have been reasonable due to the threat to the other passengers in the car, the officer surrounding the car. And it seems as though, and the defense sort of brought this out on an objection outside the presence of the jury, Vinny, were that they should have just let Daunte Wright flee. They knew his name, they knew who he was, his history of what they knew at the scene there, and that the likelihood of him being arrested at a later time was high. And so that made the threat a lower level at the time of the incident, and a reasonable officer should have considered that.
Despite the fact that they're still also investigating him for having a restraining order against someone, and they didn't know if the passenger in the car was the subject of the restraining order, because that was a big part of this whole thing too, wasn't it?
It was indeed. That was the testimony of Officer Lucky when he ran, who Daunte Wright was. There was a protection order out against him, and Johnson, they were all aware of this. They were wanting to try to find out if the passenger sitting there was the woman who had put this restraining order out on him. All of those factors, based on the testimony, other than the use of force expert, that was their totality of circumstances that raised their heightened sensitivity to the risk involved, and that goes to what the officers previous testified to.
And what happened on cross-examination of this witness? Because we saw what happened in the cross-examination of the officers. How about this expert?
Cross-examination was quite acrimonious. Earl Gray trying repeatedly to bring Seth Stoughton, this use of force expert, around to some sort of agreement with their side. It was mostly unsuccessful, and it went a lot focused on the experience of this use of force expert, Earl Gray targeting it as maybe he didn't have the expertise he claimed to have had, and he was a police officer at one point, but it had been 15 years ago, Vinny, and so possibly what he had to testify to, he didn't personally experience in his duty when he served as an officer. There was a moment where Earl Gray was able to score a point when Stoughton agreed that had Daunte Wright not resisted, had he complied, that would not have raised that level of force in the situation. And that was really the main point that I took away on cross-examination.
Okay, so basically it seems what he's saying is let him drive away. He breaks out of custody, let him get in the car, let him drive away, and deal with it later down the road. Also, the choice of words here, a reasonable officer, was what the witness was saying. Give us a little more context as to why everything is worded a certain way during some of this testimony.
Right, this was an issue early on in the testimony of Stoughton. He was talking about possibly what Kim Potter was seeing, whether or not she could see that Johnson was in or out of the vehicle, and there was a line of questioning which the prosecution asked about her perception. That was objected to, Vinny, and then there was this jury left, and there was this back and forth with the judge clarifying why it's a reasonable officer standard, not what Kim Potter thought. Let's watch.
The reason I sustain the objection is that this witness cannot testify as to what Officer Potter was aware of. He just can't do that. He can't say she wouldn't have been aware, she wouldn't have been aware that he was in danger or something, because he doesn't have any foundation for that. What he can testify to is whether a reasonable officer in Officer Potter's position would have done, but not testify as to what she was aware of. Okay.
So that was the conclusion. So this expert did go through the factors that he considered in reaching his ultimate conclusions. We have that to put up on the screen, but this is his reasonable officer conclusion. A reasonable officer would not have perceived a threat of death or serious bodily injury from Daunte Wright's conduct. He said Daunte Wright wasn't threatening. He tried to escape, yes, but he didn't offer any violence. And he used these factors. Kim Potter's attempt to use a taser. She she didn't want to use deadly force. She was trying to use a taser. And her words after the fact, her reactions, her behavior, saying, I'm going to prison, I just killed a kid. And then finally, he considered Potter's choice to use a weapon in close proximity to other officers. And that's what helped him reach his conclusion. Again, that reasonable officer standard. And at the end of this case, when the jury gets this case, Vinny, they will be instructed on that they are to also view this and weigh the evidence under a reasonable officer objective standard, not the subjective that the state was admonished for trying to inquire into earlier.
And finally, Chanley, Daunte Wright's dad took the stand today. Tell us about that moment.
Yeah, what a way to culminate a case in chief. They started with his mother, one of the first witnesses, now his father on the stand, and bringing again Daunte Wright to life inside the courtroom. Let's take a listen to part of his really emotional testimony earlier today.
All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Daunte. You see how, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
During his testimony, his wife, Katie Bryant, inside the courtroom, according to poll reporter notes, Vinny, she was sobbing so loud it almost drowned out his testimony, his tearful testimony. He talked about Daunte, loved basketball, he loved family cookouts, his favorite food was chicken, and of course he loved his son, Daunte Jr.
All right, Chanley Painter in Minneapolis. We'll talk again tonight. Let's bring in our think tank, get some reaction to really, we're at the conclusion of the prosecution's case. Joining us in Atlanta, Georgia, criminal defense attorney Eklund Mercy. In Los Angeles, California, former federal prosecutor Nima Rahmani. And in Phoenix, Arizona, the attorney who represented Jodi Arias, the author of the book series you need to read, Trapped with Miss Arias. Kirk Nurmi is with us. Okay, I have one big question that I want you guys to figure out tonight, and Eklund, I'll throw it to you, and everybody else chime in. Is the jury going to be on board for, okay, Daunte Wright is resisting arrest, is trying to get away. We've got an officer on the other side of the car leaning in. At that point, the best thing for police to do is just let him drive off, despite the fact that they know there's a protective order out on a woman relative to Daunte Wright, and they have not yet identified who the woman is in the car with him. Is that what we want police doing today? Do you think the jury's going to agree with all that?
They did it for Kyle Rittenhouse. He was able to go home after killing 2 people safely and then turned himself in. So they've been able to do that. People charged with crimes have been able to go home and, be able to, adhere to justice and, answer to warrants and things of that nature. It's happened. They've done it. This woman had training. This woman is living in the world where we had Oscar Grant case in which they had the taser confusion, and that officer was found guilty of involuntary manslaughter. We had the Botham Jean case in which Amber Geiger stated that, she didn't know she also had a taser and used her gun to kill a man in his own living room. So there should be no taser confusion. There should be no issues of mistake. She should have let him go so they can all go to court alive. So I think that the jury should be able to see that and rule accordingly.
Go ahead, jump in, guys. Nima?
Vinny, I think it was a terrible argument by the defense expert today. You don't want to overplay your hand if you're the prosecution. And to argue
It's a
that
prosecution expert today. That was a prosecution expert.
Well, yeah, the prosecution. No question. The prosecution expert overplayed his hand, so that's why I think it was a terrible argument for the prosecution, because their expert comes up there and he says that no force should be used at all. We're not talking about deadly force, what Johnson and Peterson said. We're talking about no force. You're allowing Daunte Wright to get away. When there's a protective order, there's a warrant out for his arrest as well. So they have a legal duty and obligation to arrest him. It's not a choice. There is a warrant by a judicial officer. He is to be arrested and brought to court. So I think this was a mistake that the prosecution made. I think they should have stuck with their better argument that, that you have your taser on the non-dominant side. This was reckless. This was culpable negligence. Focus on that. But to argue that he should have been allowed to escape entirely, I don't think that's something that the jury is going to buy.
Kirk?
Yeah, I agree with Nima. I could not imagine a situation where you go back, say something tragic happened to this passenger. Maybe she was the subject of the protection order. Could you imagine, Vinny, the outcry if they just said, well, he struggled a bit, so we decided to let him go? There's no way that would apply. That would be terrible, and we'd be talking about the tragedy if something were to happen to that passenger if she were the subject of the order. Yeah, and that didn't come up directly in cross. I hope the defense expert's going to come to that. But the whole time when I saw Mr. Southam up there, I thought, he's doing this from an ivory tower. The defense is going to have an expert probably from the same location, but they're never going to be able to dig out of the testimony offered by Officer Peterson and Major Johnson, who were there, particularly Major Johnson, who was in the car, who testified that he could have been injured. We're supposed to just let him drive off and take care of Officer Johnson and say, oh, we'll see you later? No way. No jury's going to buy that.
All right, folks. Think Tank is with us the whole hour. As I said, this isn't the Derek Chauvin trial, but Derek Chauvin was in court today. We're going to tell you exactly what happened, what he did, and why he did it.